Welcome to When Family Matters Become Legal Matters.
Welcome to When Family Matters Become Legal Matters with Ms. Betsy Holton, where we help navigate the legal steps needed to protect your family, your future, and your legacy. Now, Ms. Betsy is the founder of the Holton Law Group, who has years of experience guiding families through estate planning, elder law, and special needs planning. I'm Evan Mack, and today we're talking about keeping your estate plan up to date and why timing matters more than most families realize. Hello, Ms. Betsy. How are you?
Good morning. Good morning. How are you?
Morning. I'm well. I'm well. Ms. Betsy, when you talk with families, how do you usually explain why an estate plan isn't something you create once and never touch again?
Yes, yes. So there are really a number of reasons why you don't just take your plan home in its pretty binder or box or wherever that you have it in and just sit it on the shelf, right? Because so many factors can come into play that would be necessary to make changes and or updates.
Hmm.
For instance, sometimes people actually acquire more assets. That's the main reason. You may move, you may buy a new home, you may acquire a rental property or a vacation property or something of that nature. And you'll need to make sure that your plan is up to date to include those new assets. Sometimes you may even inherit assets from someone in your family or someone who cared enough to leave you a new asset. And so those are reasons to want to go ahead and make the necessary changes to your plan. Another
Mm.
really important reason that you may want to take a look at your plan is that the laws may change. I've been practicing law over 25 years, and I can tell you that the laws change. That's what our lawmakers do. They feel
Mhm.
important if they're changing the laws. So the laws change, and how your plan may have been drafted in the beginning may very well not be the best plan for you and your family now, especially if you have moved. I practice in two states. I practice in the state of Texas and the state of Florida. And
No.
both of those states have very different laws about how your assets will be distributed if they're not in your plan or you don't have a plan. And if you have a plan, they also can differ in how the law will look at the way that you have set up your distribution. So it's also very important if you were to move into another state and make sure that your plan is up to date. But then there's some pretty obvious reasons that you may want to update your plan. You have a new baby come along that you've adopted or that you have given birth to. You definitely want to make accommodations for the new one. You may get divorced or you may get married. One of those two situations can cause a reason for you to have to make changes to your plan. You also may lose your beneficiary or the person that you have listed as the individual who would take over for you or step up if you have become incapacitated and can't handle your own affairs. If
Hmm.
that person has passed away, then it's very important, if your plan has not already made provisions to address that issue, it's important that you update your plan for that reason as well.
So what are some of the life events that should prompt someone to revisit their plan, even if everything still seems fine? Is it some of the things that you have mentioned, or do you feel like it's something else?
Yeah, well, definitely the things that I mentioned, and the number one reason of the things that I have already mentioned is that the laws change.
Hmm.
Um, just within the last 4 or 5 years, we've had some changes. We're in the new administration now. They're discussing making changes to the estate tax maximum amount or minimum amount before you have to pay estate taxes. So as those numbers change and your assets are growing, it's important that you take the time to work with not only your lawyer for your estate plan, but also your financial advisor to make sure that you have the proper asset allocation in place.
Mm. People often update their wills, but sometimes they forget the beneficiary designations or account titles. How do those overlooked details affect whether a plan actually works for them?
Yes, that is the main thing that I try to work with all of my clients on. They draft these documents and they think, okay, well, I've named my children as the beneficiaries. I've named my wife as the primary beneficiary.
Hmm.
I'm good to go. But it's only in that document. And so, a lot of times, especially if you went through the trouble of doing estate planning to avoid probate, you don't take that extra step in making sure that all of your accounts mirror the language that you have in your estate planning document. For instance, if you have a trust and your trust indicates that everything needs to go to your wife and then everything would go to your children, then you need to make sure that if you have a bank account, an investment account, a stock portfolio account, or anything of that nature, that you have those beneficiaries set up so that they can, in fact, go either into the trust so they can be paid out according to the trust, or that the language in the beneficiary section with those accounts mirrors the trust or will document. Why is that important? Because if it doesn't mirror that, then you end up in a situation where those assets are now outside of the trust, which means you have to go through the probate process all over again. It's also very important that if you have those life changes, as I stated, getting married and or getting divorced, that if you're getting divorced and you've left your ex-spouse's name on that contract as a beneficiary, that company is obligated to pay to the person who is listed as the beneficiary, not to whoever you think or wanted it to go to after that divorce. So you leave yourself vulnerable to allowing your asset to pass to a ex-spouse because you have not made those changes. So yes, it's very important that you take the time. If your attorney does not automatically follow up with you in a certain period of time, to make a note yourself to reach out and say, "Hey, is there anything I need to be concerned about? Um, I've just opened a business. Do I need to make some plans about,
Hmm.
how I would handle my business if something were to happen to me? Is that something that you help out with?" So there are just a number of reasons why it's so important that we take the time to review our plans.
So you talked about it earlier, but between states like Texas and Florida, what kind of differences in state law make this update necessary or make an update necessary?
Yeah, yes, for sure. So, for instance, in the state of Florida, if you pass away and you're married, your wife gets everything. In the state of Texas, if you pass away, even because it's a community property state, if you pass away without a will, your wife is only entitled to half. If you have children, your children are entitled to your half. So your wife gets to keep her half, but then the children get your half, right?
Mm,
Now, if you don't have any children, then the wife would be able to probably receive everything. But there are some other rules about that as well. So you have to be very careful that you are looking at how the family dynamics line up. There are even differences in Texas if the children that are your heirs, your lineal heirs, are the same children, that your wife is the mother of those children. So you would have some different types of distribution according to the intestate succession plan. So if your will, which fortunately they do mirror, if you draft a will or trust in the state of Florida, it needs to be drafted with you signing it in the presence of two witnesses and a notary. It's the exact same rule in Texas. So those mirror, fortunately. So as far as the logistics of the document is concerned, you meet that definition and you can meet that specificity. But if there are other, if for whatever reason the document can't be located, or you don't actually do a plan, the state's plan is very, very different in the two states.
mm. If someone's financial situation grows or shifts, maybe a new home, inheritance, or business interest, how does that change the type of plan they may need?
Oh, yes, that could change tremendously. For instance, if you were to start a new business, you want to create a business succession plan and either add that to your trust document or your estate plan documents, or you
Mm,
want to now really, really take the time to create the estate plan,
right.
because you have created this business to provide for your family. And if you don't also do the succession planning for the business, then the ability for that business to sustain itself after you are no longer able to could very well go away. You may no longer be able to physically work in your business and provide the most valuable asset that your business may have, which is you. So if you don't put together a proper succession plan so that the business can continue, then all of the assets and all of the support that that business was providing for you and your family may no longer be there.
Mm. How often do you recommend families review their documents, even if they have had any of those major life events?
Yes. So obviously, if you remember, obviously, if you have a baby, you're going to think about it most
Yeah.
likely, or and most likely if you're going through a divorce. But we have a 3-year calendar at our firm where we automatically reach out to the client and say, "Hey, I'd like to sit down with you and go over some of the changes in the law. I'd like to go over." Um, some of the changes that may have happened in your own life, and see if there's a need for us to make any updates to your plan. There are times that there really is not any reason whatsoever to make those adjustments, but I have found that quite often it really is a need to make a few, even if minor, adjustments to the plan.
What kinds of problems have you seen when someone passes away with the plan that's outdated or maybe a plan that's incomplete?
Yes, yes. So I have run into situations where mom has created a plan. And she has named child A as the primary beneficiary, or the person to be the administrator or executor of the estate, the one who's responsible for making sure that all of the assets are distributed according to the way that the plan was conceptualized. And that person passed away before mom. And unfortunately, some of the older plans, the thought of going through a process of trying to determine if I needed a contingency person wasn't always there. People would just say, okay, well, I'm just going to name my oldest kid as my executor and I'm done.
Yep.
But now we walk through that process with our clients. Well, what if something happens to the person whose name you've given me? Can we come up with someone else who may need to step up and step in their stead? And so that happens a lot. We only have the one name. That person's now deceased. And so we almost end up with a situation where there is no one there at all. And so we have to sometimes go through the probate process to come up with the next person who can step up and take care of the assets.
Mm. So, for a listener who hasn't looked at their estate plan in years, what's a simple starting point to get everything back on track?
It's actually the very same starting point that you have if you have not done a plan at all.
Mm,
Stop and take an inventory of what you have, because if you don't know what you have, you don't know what you need to make sure you've made the adjustments for, right?
mm.
And so once you make that assessment as to what assets you have, you can contact the lawyer, or yes, contact the lawyer. Don't do an or. And make sure that the new assets are accounted for properly in your plan, and that you have a contingency or backup in your plan if there are individuals that you have named in that plan.
Awesome. Miss Betsy, thank you so much.
Sure.
Thank you all for listening to When Family Matters Become Legal Matters. If today's conversation was helpful, be sure to subscribe, leave a review, and share to show someone who might need it. For more resources or to connect with Miss Betsy Holton and the Holton Law Group team, visit dfwtrustandwills.com. Your family's future is too important to leave to chance, and the right plan can make all the difference. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.